Case number 1, Nyyon Sanders. In the legal world, capital murder is the most severe label you can put on a human being. It's a charge reserved for the most heinous acts, the kind of crimes where the state of Alabama believes the only fit punishment is the death penalty. In 2022, Nyyon Sanders was slapped with that very charge. Alongside his brother Kevin Sanders, Nyyon was accused of the murder of Trayton Moore in Mobile, Alabama. In almost any other era of American justice, a capital murder charge meant you stayed behind bars in a high-security cell until the day a jury decided if you'd live or die. But Nyyon Sanders didn't stay behind bars. In a move that would eventually spark a firestorm of local outrage and national debate, a judge allowed Sanders to walk out of the Mobile County Metro Jail on bond. The court's justification for this release was built on a foundation of technology, a GPS ankle monitor. They told the public that as long as Sanders was wearing this electronic tether, he was under strict supervision. But anyone who understands the reality of these devices knows the truth. They aren't high-tech cages. They are plastic boxes held on by rubber straps. They don't have the power to stop a man from walking into an apartment complex with a firearm. They don't have the power to prevent a violent impulse from turning into a tragedy. They are tracking tools, nothing more. And even as a tracking tool, the system is only as reliable as the battery powering it and the human beings watching the screen on the other side. For 2 long years, Nyyon Sanders lived his life in the community he was accused of terrorizing. He walked the same streets as his neighbors, shopped at the same stores, and breathed the same air, all while the family of Trayton Moore was forced to wait for a trial that seemed to be stuck in a cycle of endless delays. This is the part of the bond system that often goes overlooked, the psychological toll it takes on a community to see a man accused of a capital crime living among them as if nothing happened. The supervision over Sanders was a digital illusion, a safety net made of thin wire and weak batteries. Everything came crashing down on Monday night, November 11th, 2024. This wasn't just a technical glitch or an unfortunate accident. It was a total top-to-bottom collapse of the safeguards meant to keep the public safe. At approximately 5 p.m. that evening, Sanders intentionally allowed the battery on his ankle monitor to die. He didn't plug it in, and he didn't notify his monitoring officer. In that moment, the state of Alabama lost sight of a man they were supposed to be watching 24/7. Sanders effectively became a ghost in his own city. But the real failure, the part that truly keeps the citizens of Mobile up at night, happened in the offices of the private company AccuPoint, hired by the court to monitor those GPS signals. When a high-risk capital murder suspect's monitor loses power, it should trigger an immediate high-priority alert. It should be treated with the same urgency as a prison break. Instead, there was a massive, inexcusable communication lag. Despite the device going dark shortly after 5 p.m., AccuPoint failed to notify authorities until 8 a.m. the following morning. For 15 hours, the police had absolutely no idea that Sanders was off the grid. While the bureaucrats and the monitoring company were failing to pick up the phone, Sanders was on the move. He didn't use this window of darkness to run away or hide from his upcoming trial. Instead, he and his brother Kevin allegedly traveled to the Dauphin Gate Apartments on Dauphin Island Parkway, a restricted area Nyyon was legally barred from entering as a condition of his bond. At approximately 9:20 p.m., while the system still technically listed him as under supervision, the silence of the apartment complex was shattered by gunfire. When the Mobile Police Department arrived at the scene, they found 25-year-old Joseph Evans Jr., known to his family and friends as Baby Joe, deceased between 2 buildings. Investigators later revealed that the killing occurred during a robbery, leading to a fresh charge of first-degree robbery alongside the murder count. Joseph was a completely innocent man who had the fatal misfortune of being in the path of a predator that the state of Alabama had deemed safe enough to be out on bond. He was a son and a member of a family that now has to live with the reality that his death was entirely preventable. The fallout from this second murder was immediate and explosive. Mobile County District Attorney Keith Blackwood did not mince words, publicly blasting the bond system and the private monitoring company for their roles in this catastrophe. The outcry was so severe that Mobile County judges took the unprecedented step of barring AccuPoint from operating in the county entirely. The Mobile County Sheriff's Office was forced to take all monitoring duties using shadow track technologies, an emergency transition that cost the taxpayers an estimated $1.6 million. The tragedy of Nyyon Sanders is a chilling case study in the flaws of modern bond reform and the privatization of law enforcement duties. It exposes the dangerous over-reliance on third-party companies to do the job of a physical prison. It shows that when the system fails, and it will fail, the cost is measured in human lives. Sanders was eventually tracked down and hauled back into custody, where bond was rightfully denied. He is now held at the Mobile County Metro Jail, awaiting a trial scheduled for January 2025. But for the families of both Trayton Moore and Joseph Evans Jr., the justice being promised now feels like an afterthought. They were told the system would watch him. They were told the public was safe. They were told the ankle monitor was a substitute for a cell. This wasn't a failure of technology, it was a failure of judgment by the courts and a failure of duty by the monitoring company. Two families are now joined in a brotherhood of grief, all because a battery was allowed to die and a man accused of the ultimate crime was given a second chance he never should have had. Joseph Evans Jr. became a victim of a system that forgot its primary job is to protect the innocent, not accommodate the accused. This is the dark reality of killers who strike while out on bond, a reality where the digital leash is nothing more than a plastic souvenir of a failed policy that leaves bodies in its wake. Case number 2, Julian Ingram. In the vast, sun-scorched expanse of New South Wales, the town of Lake Cargelligo is the kind of place where people go to find peace, not to witness a massacre. But on January 22, 2026, this rural community became the backdrop for a failure of the justice system so profound it has left an entire nation reeling. At the center of this tragedy is 37-year-old Julian Ingram, also known as Julian Pierpoint. Like Nyyon Sanders before him, Ingram is a name that now stands as a testament to the deadly gap between legal theory and public safety. When we talk about domestic violence, we often use the term red flags. We talk about them as if they are subtle hints or quiet warnings. But in the case of Julian Ingram, the red flags weren't just waving, they were screaming. Ingram wasn't a stranger to the police, and he certainly wasn't a stranger to the courts. At the time of the bloodshed that would come to define him, Ingram was out on bail. He had pleaded not guilty to a string of domestic violence charges, including stalking, assault, and property damage, all centered around his relationship with 25-year-old Sophie Quinn. The state of New South Wales had issued an apprehended violence order against him. On paper, that order was a shield, a legal barrier designed to keep a predator away from his prey. But as any victim of coercive control can tell you, a piece of paper has no physical weight. It cannot stop a bullet, and it cannot halt a man driven by a toxic cocktail of entitlement and revenge. The court looked at Ingram's history, which included a 2021 conviction for grabbing a family member by the throat, and decided that he was a candidate for bail. They decided that the community, and specifically Sophie Quinn, could be kept safe through the mere promise of a man who had already proven he had no respect for the law or the sanctity of human life. The horror began on Waukesha Street. It was a Thursday afternoon that should have been filled with the ordinary rhythms of life. Sophie Quinn, just 25 years old and 7 months pregnant with a son she planned to name Troy, was in a car with her partner, 32-year-old John Harris. They were likely planning for a future that Ingram had already decided they wouldn't have. According to investigators, Ingram didn't snap. He didn't have an impulsive moment of rage. Criminologists analyzing the case point to a much darker reality: premeditation. This was the calculated execution of a plan fueled by coercive control. Ingram allegedly approached the vehicle in a white Ford Ranger and opened fire. In those few seconds of violence, Sophie, her unborn child, and John Harris were executed. The brutality of the act is difficult to overstate. To kill a pregnant woman is not just a murder, it is an attempt to erase the future. But Ingram wasn't finished. This wasn't a crime of passion that ended once the primary target was gone. This was a scorched earth campaign. Later that same day, the violence migrated to a home on Walker Street. There, Ingram allegedly turned his weapon on 50-year-old Nerita Quinn, Sophie's aunt, and 19-year-old Caleb McQueen. Nerita, a beloved school cleaner and pillar of the community, was killed instantly. Caleb was shot in what police describe as crossfire, surviving with catastrophic injuries. He remains a survivor of a day that saw 3 generations of a family impacted by the muzzle of a gun. The sheer logistics of the day suggest a man who was moving with purpose. He wasn't hiding yet, he was hunting. In the immediate aftermath, the New South Wales police launched Strike Force Doberta, but Ingram had a head start, and he had a disguise. He was last seen driving a white Ford Ranger utility vehicle, registration DM-07-GZ. This wasn't just any truck, it was his council work vehicle, equipped with council signage, an emergency light bar, and even the number 1947 visible on the side. It was the ultimate tool for a fugitive, a vehicle that signaled authority in utility rather than danger. As the days turned into weeks, the search shifted to the remote, rugged terrain of the Mount Hope region. This is a landscape that swallows people whole. Dense scrub, red dirt, and temperatures soaring into the high 40s. Police remain confident that Ingram is still alive, utilizing his extensive knowledge of the bush and local brush-cutting camps to survive. But more disturbingly, they believe he may be receiving help. The idea that a triple murderer is being shielded by members of a community is a chilling thought. It speaks to a level of loyalty or perhaps fear that transcends the law. While the tactical units comb through the bush, a different kind of investigation is happening in the halls of government. A critical incident investigation has been launched to answer the one question that has the public demanding answers. How was he allowed out? Ingram had been arrested just weeks prior for domestic violence offenses against Sophie. He had reported to the police station at 8:12 a.m. on the very day of the murders, complying with his bail conditions just hours before he allegedly picked up a firearm he was never legally allowed to own. The parallels between Nyyon Sanders and Julian Ingram are haunting. In both cases, the justice system relied on tools of management, a GPS monitor in Alabama, and the honor system of bail in Australia. Both systems failed because they underestimated the lethality of the individual. Experts in domestic violence suggest that the period immediately following a victim's attempt to seek legal protection is the most dangerous. This is when the coercive controller feels his power slipping away. By granting Ingram bail, the court essentially handed him a window of opportunity. As of February 12, 2026, Julian Ingram remains at large. He is described as having an Aboriginal or Torres Strait Islander appearance, roughly 165 to 170 centimeters tall, with a medium build and dark hair. He is considered armed and extremely dangerous. He is a ghost in a white Ford Ranger, a man who exploited every loophole in the system to commit an act of unspeakable cruelty. For the families of Sophie, John, and Nerita, there is no closure, only a lingering fear that as long as Ingram is free, the nightmare isn't over. The town of Lake Cargelligo remains on edge, a community haunted not just by a killer, but by the knowledge that the system meant to protect them was the very thing that set the predator free. The story of Julian Ingram isn't just a story of a manhunt, it's a story of a warning ignored, a life cut short, and a justice system that once again failed to see the monster standing right in front of it. Case number 3. Darrell Edward Brooks, Jr. If the cases of Nyyon Sanders and Julian Ingram were examples of a system failing to predict violence, the story of Darrell Edward Brooks, Jr. is the story of a system being held hostage by it. On November 21, 2021, the community of Waukesha, Wisconsin gathered for its 58th annual Christmas Parade. It was a milestone event, the first time the parade had returned since the pandemic. The theme was Comfort and Joy, a celebration meant to heal a city emerging from years of isolation. The streets were lined with children in winter coats, high school marching bands, and the famous Milwaukee dancing grannies. But at 4:39 p.m., that joy was shattered by the roar of a red 2010 Ford Escape. Darrell Brooks didn't just drive through a parade, he used his vehicle as a scythe. Witnesses described the SUV moving at 40 miles per hour, swerving in a deliberate, sickening zigzag pattern designed to hit as many people as possible. He didn't tap his brakes, he accelerated. By the time the vehicle finally exited the parade route, 6 people were dead, including 8-year-old Jackson Sparks, who was marching with his baseball team, and 62 others were left with broken bodies. The trauma was caught on a dozen different cell phone cameras and a city live stream, showing a nightmare that would become one of the most documented mass killings in American history. The tragedy of Waukesha was preceded by a systemic failure that mirrored the cases we've already discussed. Just 3 weeks before the massacre, Brooks had been arrested for allegedly punching the mother of his child and running her over with that very same Ford Escape. Despite an extensive criminal record dating back to 1999, including a felony sex crime conviction in Nevada, a Milwaukee prosecutor recommended a bail of just $1,000. It was a sum Brooks paid with ease, walking out of jail just 2 days before he would turn the Waukesha parade route into a war zone. The Milwaukee District Attorney's Office later called the low bail a human error caused by an overworked assistant, but for the families in Waukesha, that error was an invitation for a predator to finish what he started. What followed was one of the most bizarre and frustrating legal proceedings in American history. Brooks chose to represent himself, a move that turned the 2022 trial into a circus of disruption. Many watching from the outside asked a simple question: why was his behavior being accepted? To the casual observer, it looked like the court was being bullied. Brooks shouted over Judge Jennifer Dorough, argued sovereign citizen legal theories that have no basis in law, and frequently removed his shirt or built walls out of legal boxes to hide from the camera. He spent hours arguing over grounds for objections, claiming the state of Wisconsin wasn't a living person and therefore could not file a claim against him. He even tried to claim his name was not Darrell Brooks, but rather a corporate entity. But the acceptance of this behavior wasn't a sign of weakness. It was a strategic necessity to ensure justice was final. Judge Dorough knew that if she silenced Brooks too aggressively or denied his right to self-representation, it would create a reversible error, a legal loophole he could use in an appeal to get his conviction overturned. She allowed him to speak for over 2 hours during his closing remarks, where he offered a rambling, tearful apology that many victims saw as a final act of manipulation. By allowing him the rope to hang himself legally, the court ensured that when the guilty verdicts came down on all 76 counts, they would be ironclad. The sentencing hearing was a moment of reckoning. For 2 days, victims and their families stood just feet away from Brooks, describing the path of destruction he had left behind. They spoke of the dancing grannies, women who had survived decades only to be mowed down while doing what they loved. They spoke of children who now jump at the sound of a car engine. When Judge Dorough finally handed down the sentence, it was historic. 6 consecutive life sentences without the possibility of parole, plus an additional 762 years and 6 months in prison. She told him directly, "Frankly, Mr. Brooks, no one is safe from you." Even from behind the walls of his cell, Brooks remains a shadow over the legal system. As of early 2026, he is currently incarcerated at the South Dakota State Penitentiary, having been moved out of Wisconsin for security reasons. True to his disruptive nature, he has continued to flood the courts with appeals. He recently requested a 10th extension to file his latest appeal, citing difficulties accessing his case files due to a prison lockdown. He claims he is being monsterized and that his constitutional rights are being violated, yet he shows no remorse for the lives he ended. The case of Darrell Brooks highlights the dark side of due process. It shows how a single person can weaponize the very laws designed to protect the innocent, to delay their own accountability. While Brooks sits in a cell in Sioux Falls, the city of Waukesha remains Waukesha strong, bound together by a tragedy that proved that while a predator can disrupt a courtroom and a parade, they cannot break the resolve of a community. His trial was a circus, his defense was a lie, but his cage is very real. This case stands as the ultimate example of why we cannot afford human error in the courtroom or the bail office. When we talk about $1,000 bonds for violent offenders, we aren't talking about money, we are talking about the lives of people like Jackson Sparks and the Dancing Grannies. We are talking about the price of a system that sometimes forgets who it is truly meant to protect. The pattern we're seeing today is becoming impossible to ignore. These aren't just isolated incidents, they're cracks in the foundation of the justice system that affect communities across the globe. If you believe these stories need to be told and that accountability matters, please take a second to hit the like button. It tells the algorithm that this content is important and helps us reach more people who care about justice. I also want to know your thoughts. Drop a comment and let me know which city or country you're watching from. I'm always looking through the comments to see how far these stories are traveling, and I'll be picking one of you for a special shout out in our next video. Let's get back to the cases where the failure of the system took an even darker turn. Case number 4, Kirkland Warren. If the justice system is designed to act as a resilient dam against the tide of human violence, then the case of Kirkland Warren is the story of a dam that was riddled with structural holes from the very beginning. The deaths of 27-year-old Michelle Melendez and her 7-year-old daughter Lila Stewart in March of 2023 represent a catastrophic, multi-state failure of judicial oversight that is almost impossible to reconcile with the concept of public safety. It is a case that forces us to look at the terrifying reality of what happens when a violent offender is treated with a leniency he never earned, and how that leniency paved a direct path to a rural ditch in Waukesha, Washington, where a mother and daughter were left like refuse. To understand the horror of 2023, we have to travel back to November 27, 2017, in Stuttgart, Arkansas. There, a 20-year-old Kirkland Warren shot his passenger Curtis Urquhart with a .22 caliber handgun. The motive was as trivial as it was chilling. Urquhart had allegedly asked for money one too many times. Warren dumped the body in a ditch and later claimed self-defense. Despite being charged with first-degree murder and abuse of a corpse, crimes that carry the weight of a lifetime, Warren was granted a $250,000 bond. He posted it, walked out of jail, and eventually migrated to Vancouver, Washington, while his murder trial in Arkansas languished in the system for years. This was the first fatal hole in the dam. A man accused of a cold-blooded killing was allowed to traverse the country, a wolf among sheep, with no real-time monitoring of his escalating behavior. By 2022, Warren had found a new target in Michelle Melendez. The red flags were not just present, they were explosive. On December 13, 2022, Warren and Melendez argued at her apartment. As he left, Warren fired a gun at her balcony window while she was looking out. It was a clear attempt at intimidation, a warning shot that the system should have heard loud and clear. When police finally caught up with him in March 2023, Clark County prosecutors were fully aware of his history. They knew about the pending murder charge in Arkansas. They performed a danger assessment that scored Warren at a 31 on a scale of 1 to 18. To put that in perspective, he was nearly double the threshold for what the state considers an extreme risk to a victim's life. The prosecution asked for $100,000 bail. Judge Susan Clark granted it, but Warren violated the no-contact order within hours of his first appearance, calling Melendez from jail to pressure her into dropping the charges. Despite this immediate defiance, the system continued to churn in his favor. A few days later, a district court judge ordered a GPS monitor as a condition of release. However, due to a bureaucratic technicality involving the dismissal and refiling of charges into Superior Court, the monitor was never fitted. On March 8, 2023, Kirkland Warren walked out of jail for the second time in his life while facing violent felony charges. He was a ghost, unmonitored and unstopped, with his target clearly in sight. 4 days later, on March 12th, the nightmare reached its zenith. Melendez and her daughter Lila were last seen alive getting into Warren's burgundy Dodge Charger. What happened inside that car is a descent into pure depravity. According to investigators, Warren shot Michelle in the head and left her body in the passenger seat while he went to a house party. He then used Michelle's phone to lure 7-year-old Lila into the car. The details revealed by the prosecution were nauseating. Warren didn't just kill the child, he sexually assaulted her before shooting her twice in the head. He then spent the next several days Googling how to beat murder, killing the only witness, and how to get blood out of a car seat. The bodies of Michelle and Lila were found 10 days later, dumped down an embankment in a rural area east of Washougal. The discovery shattered the Vancouver community. Hundreds gathered for vigils, but the grief was poisoned by a justified fury. Why was a man with a pending murder charge in Arkansas and a 31 out of 18 danger score in Washington allowed to walk the streets? Why was the GPS monitor, which could have alerted police the moment he approached Michelle's home, never attached to his ankle? It was a total, top-to-bottom collapse of the safeguards meant to protect the vulnerable. The system looked at a man who had already killed once and was threatening to kill again, and it essentially gave him a roadmap to finish the job. In September 2024, just days before his trial was set to begin, Warren finally ended the legal charade. Facing overwhelming forensic evidence, including his DNA on Lila's body and the victim's blood in his Charger, he pleaded guilty to aggravated first-degree murder for Lila and second-degree murder for Michelle. He also entered an Alford plea for the child molestation charge, a move that allowed him to maintain his innocence while acknowledging the state had more than enough evidence to convict him. On October 8, 2024, he was sentenced to life in prison without the possibility of parole. Because Washington does not have the death penalty, this was the maximum sentence allowed by law. Even then, the reach of his crimes extended back to where it all started. As part of his plea deal, Warren agreed to plead guilty to the 2017 murder of Curtis Urquhart in Arkansas, finally closing a case that had remained open for 7 agonizing years. Kirkland Warren will spend the rest of his life behind bars, but that reality provides little comfort to a family that lost 2 generations in a single afternoon. The tragedy of Michelle and Lila isn't just about the evil of one man. It's about a legal system that saw the danger, measured the danger, and then opened the door for it anyway. As we look at the timeline of this case, we see a man who was given every opportunity to reform, or at least be restrained, and a system that failed to act until it was too late. From Arkansas to Washington, the failure to communicate the lethality of Kirkland Warren resulted in a loss that can never be repaid. He is currently serving his life sentence, a predator finally caged, but the names Michelle Melendez and Lila Stewart remain etched in the conscience of a community that was forced to learn the hardest way possible that when the system fails, the cost is measured in lives. We must ask ourselves how many more red flags need to be raised before a danger assessment actually results in the protection of a child. Case number 5. Travis Lang. The case of Travis Lang in Indianapolis represents a unique and deeply polarizing chapter in the ongoing national debate over bail reform and the role of third-party intervention in the judicial process. While our previous cases often involved systemic failures by judges or technical glitches in monitoring hardware, this story highlights the unintended, lethal consequences of charitable intervention. On October 1, 2021, 24-year-old Dylan McGinnis was sitting in a car on East 11th Street, not as a participant in a crime, but as a protector. Dylan was there to support a friend who was struggling with the heavy, suffocating weight of substance abuse, hoping his presence would keep her safe during a dangerous transaction. Instead, that selflessness put him directly in the path of a man who should have been behind bars. The catalyst for this tragedy was a dispute over the price of Xanax and heroin. Travis Lang, a 23-year-old known to investigators as a frequent drug dealer in the area, was arguing with a woman in the vehicle over a difference of a mere $20, the price of a cheap meal. When the woman told Lang to leave the car, the situation escalated with terrifying, senseless speed. Lang exited the vehicle, pulled a handgun, and unleashed a hail of 9 bullets into the car. The woman was wounded, but Dylan McGinnis, an innocent bystander whose only crime was caring too much for a friend in crisis, was struck multiple times and killed. It was a cold-blooded execution over a trivial sum of money, executed by a man who had been handed his freedom by a system that failed to see the danger he posed. What makes the death of Dylan McGinnis a flashpoint for national outrage is the specific mechanism that allowed Travis Lang to be on that street corner in the first place. 9 months prior, in January 2021, Lang had been arrested for possession of cocaine. At the time of that arrest, he was not a first-time offender or a victim of a single bad decision. He had a rap sheet dating back to 2018 that consisted of multiple pending felony cases, including burglary, auto theft, and resisting law enforcement. Despite this clear and escalating pattern of lawlessness, his bond was set at a relatively low $5,000 cash. To a drug dealer with a network, this was a hurdle. To a nonprofit organization, it was a mission. Enter the Bail Project, a national nonprofit organization that aims to combat mass incarceration by paying bail for low-income individuals. The organization paid a portion of Lang's cash bond, facilitating his pre-trial release. Their justification, later echoed in public statements, was that Lang had a supportive family and no prior history of violent convictions. They pointed to the fact that he had attended all his court dates for his pending cases as proof of his success. But this defense ignores the reality of the druggy lifestyle that investigators say Lang maintained while out on bail. For Lang, the bail assistance didn't lead to a path of rehabilitation. It provided a window to return to the lucrative and violent world of the drug trade, which ultimately led to the muzzle of a gun on East 11th Street. The fallout from this case was immediate and politically explosive. It was the second time in less than 6 months that an individual released with the help of the Bail Project in Marion County was later charged with a brutal murder. Just months earlier, Marcus Garvin had been released on a $1,500 bond paid by the organization after he was accused of a stabbing at a gas station. Once free, Garvin cut off his GPS ankle monitor and murdered his ex-girlfriend, Christy Holt, hiding her body under a bed. The back-to-back tragedies of Holt and McGinnis created a firestorm of criticism, leading to intense questions about whether charitable bail funds were inadvertently subsidizing violent crime by failing to account for the total picture of a defendant's risk. In the courtroom, Travis Lang's attempt to evade responsibility eventually hit a dead end. In August 2023, a jury saw through the excuses and the chaos of the drug trade. He was convicted on a litany of charges, including murder, felony murder, attempted murder, 2 counts of robbery resulting in serious bodily injury, and carrying a handgun without a license. At his sentencing in September 2023, the weight of his actions finally caught up to him. He was no longer a success story or a data point for the bail reform movement. He was a convicted killer whose freedom had been purchased at the cost of an innocent man's life. For Dylan McGinnis's mother, Nikki Sterling, the conviction brought a measure of legal finality, but it did not erase the systemic questions that haunted her.
She has spent the years since her son's death advocating for legislative change, questioning why taxpayer-funded grants were supporting organizations that facilitated the release of repeat felons without proper oversight. She described Dylan as a man who cared for the broken and the outcasts, an irony that wasn't lost on the community. A man who died trying to save someone from the drug trade was killed by a man the system let back into it. Her son's death became the primary catalyst for new Indiana laws aiming to restrict the ability of charitable organizations to post bail for those accused of violent crimes or those with a significant criminal history. The story of Travis Lange is a sobering reminder that non-violence on a rap sheet is not a predictor of future peace. When the justice system, or those intervening in it, focuses solely on the single charge at hand, while ignoring a broader, multi-year pattern of burglary, theft, and drug dealing, the results can be fatal. Dylan McGinnis died because the system and its partners prioritized a repeat offender's right to pretrial liberty over the community's right to basic safety. It is a case that remains the ultimate example of how good intentions, when applied without a rigorous and realistic risk assessment, can lead to the most tragic and irreversible ends. Travis Lange is now behind bars, serving a sentence that reflects the gravity of his crimes. But the debate he sparked continues to rage in every courtroom where a bond is set and a life hangs in the balance.
The 5 cases we've looked at today are more than just headlines. They're failures of a promise. The justice system is built on the promise that if you follow the rules, the system will protect you from those who don't. But for the families of Dylan McGinnis, Michelle Melendez, and so many others, that promise was broken by a signature on a bond or a technicality in a courtroom. As we continue to navigate the complex debate over bail reform and judicial oversight, we have to ask ourselves, how many more human errors are we willing to accept? Before we go, I want to give a special shout out to one of our subscribers, Rob from the UK. Thank you for being a part of this community. If you want a shout out in a future video, make sure to leave a comment down below with your thoughts on these cases, and let me know where you're watching from. I read through as many as I can, and I'll be picking more of you to feature next week. If you found this video important, please hit the like button and subscribe so you don't miss our next investigation. I want to hear from you. Which of these cases do you feel represents the biggest failure of the system? Let's keep the conversation going in the comments. Stay safe, stay vigilant, and I'll see you in the next one.